I'm glad to see all of you here to think about, to speak about students with disabilities in the public schools and advocating for those students. I just want to take a brief minute or two to put that in a context, not the context that Eilleen will put it in, which is one of statutes and regulations and decided court cases, but a little bit of a broader statute so that we can think about it critically from a comparative and historical perspective. I'm not going to attempt, although I have done it in 6 minutes, I haven't done it in 1 minute, an overview or a history of human rights law, but I want to situate, if I may, the question of the rights of students with disabilities in the broader context of human rights. The first thing that you have to know about human rights, I think, is that human rights have always been aspirational. Human rights are bound up with a dream. When Robert F. Kennedy said, other people look around and see what is and ask why, I dream of what never has been and ask why not, he was really speaking for a generation. He said that 51 years ago. And sort of post-war generation of dreamers, among the most influential in human rights was Eleanor Roosevelt, a personal hero of mine. And she, at one point, published her own personal nightly prayer, which includes this line. And you know that, I think that everyone in this room knows that she was the head of the commission that drafted the Universal Declaration on Human Rights that was adopted by the General Assembly of the United Nations in 1948 and remains the foundational document of human rights in the world. So in her prayer every night, she would say, "Open our hearts to simple beauty all around us, and our hearts to the loveliness men hide from us, because we do not try to understand. Save us from ourselves and show us a vision of a world made new." So you can hear in those words a dream, and I think that that dream can be a North Star to guide us to a place beyond the present problems, the inadequacy of policies, due process, the inadequacy of existing statutes and regulations, to a point where we really do make good on the promise of equal opportunity that exists in this country. I mentioned to Eilleen that I just came back from sessions with 28 countries of the European Union on the question of inclusion. And it is very interesting to compare. Everything that we study should be studied comparatively and historically. That's how you think about it. You think about things that are real by comparing them to other things that are real. That's another way of describing what thinking is. When we think about inclusion, we very often don't think about the way other people around the world think about it. And in the European Union, including people with disabilities is at the top of the agenda of inclusion. I don't think anyone would say that it's the top of the agenda of inclusion here. But in this country, I want to just refer to two things about human rights as we think about them today. The first is that in the preamble to the Universal Declaration and in its first article, the most important idea is human dignity. So where in the U.S. Constitution did the framers speak about dignity? Anyone know where they speak about dignity in the U.S. Constitution? So the U.S. Constitution, which is 4,000 words, 240 years old, the oldest written constitution in the world, does not include the word dignity. It's a very important word in the jurisprudence of Justice Kennedy, as I think all of you know. And it's subject to the vulnerability that dignity is not a human right, although it's not a constitutional right. It's a human right. It's a constitutional value. There's a very good book by former Justice of the Israeli Supreme Court, Aaron Barak, about the difference between constitutional rights and constitutional values. It's derived from such things as the right to privacy in the Fourth Amendment and so on, equal protection in the 14th Amendment. So we're vulnerable in that way. No constitution, there are 193 written constitutions in the world, no constitution written before 1945 includes the word dignity, even though dignitas, the Latin word, exists in jurisprudence for 2 millennia. And every constitution written since 1945 includes the word dignity. So that's an interesting watershed in thinking about human rights. And in thinking about the rights of people with disabilities, I find it very interesting, and those of you who want to follow up on this, I'll just give you the citation. Within the Universal Declaration, it's Article 26 that describes education as a human right. Again, this is not binding as law in federal courts, although it is occasionally cited. Some state and local courts have applied it as binding law. In the discussion of the right to education, in Article 26, in paragraph 2 of Article 26, and now I read from the Declaration, education shall be directed to the full development of the human personality. The full development of the human personality. An idea which, by the way, you find in the Declaration of the Rights of Man from 1789 at the time of the French Revolution. So, if we're talking about the full development of the human personality as a human right, which it is very difficult to see, and I hope that this idea that dignity and the full development of the human personality are values. They may be aspirational, they may not be written into a decision by a judge or a judge of a court that is going to lead us into a place of universal respect for dignity or for the development of personality. It is nevertheless a goal. And I hope that in exploring these issues in all of their particularity, through the statutes and through the regulations and through the court cases and through the struggles with forms of disability that have become more prominent, not just a question of greater awareness, but mental health and disabilities that are related to it. There is a greater incidence and in many cases an inability to deal with the persons who are afflicted in a way that truly reflects the dignity that they enjoy as a human right, and the fact that we owe them, we have a duty to them to see to it that they can enjoy the full development of their personalities. So I now turn it over to Eilleen, and I unfortunately will have to leave. I wish you a successful conference, and more than that, I think together we hope for more equality of opportunity, more rights for people with disability, more compassion for people with disabilities, and more inclusion of those people in everything that we cherish about the society we live in and all the rights that we enjoy. Thanks.
I think I can talk into this mic and not this. Is that correct? Okay, good. Hi, thank you for inviting me to here today. Thank you, Dean. I appreciate the introduction. I'm Eilleen Buckley. I'm an attorney with Long Island Advocacy Center. I've been doing this work for over 20 years. It's a passion of mine. It's personal to me. I'm a parent of a student with a disability. And so I'm happy, as part of our mission, to explain and to discuss how we can do a better job of creating educational equity for all of our kids. There we go. My big takeaway for you today is really the concept that education is a civil right, no less than any other civil right, and so it ties right into the Dean's comments. And the concept that it's practically a very new civil right. It wasn't even acknowledged. It's only been in existence for 40 years. And that prior to that, which is shocking to me, kids with disabilities were legally entitled to be excluded from school. So with that, to frame our conversation, think about how we move forward. The laws that govern this area are, and it's important to know the laws because they're really good laws. And the thing that's important for parents and advocates and attorneys is to keep in mind is that this law is a good law for families and for kids with disabilities. However, parents who are unaware of it and don't know how to use it can not be the beneficiary of it. So it's really our job as advocates to make sure that people understand the law and that parents especially are empowered through this law and through our work to be able to enforce it to benefit their students. So I know we're going to be short on time. I know I talk really fast. I want to apologize for that, but I will make the PowerPoint available to Touro so that if you want a copy, we can email it to you. So if I don't get through it, my apologies. But so I'm going to go rather quickly through the laws, just so that you're aware. Section 504 of the Rehabilitation Act of 1973 and Title II of the Americans with Disability Act of 1994 prohibit discrimination on the basis of disability in programs that receive federal financial assistance and by state and local governments. So important to know. Section 504, I'm not going to read this because it'll take too much time, but it defines what the law, how they define disability. The Individuals with Disabilities Education Act, I didn't give you the site. However, I can tell you it's 20 U.S.C. 1400, and it's the federal law that protects the rights of disabled students to receive an education. And in New York, that law is implemented through Article 89 of the New York State Education Law and Part 200 of the Commissioner's Regulations. If you know the Part 200 regulations, you know the law, and that's what governs how we advocate for kids. The advocacy work that's really relevant right now is to protect students with disabilities because they can only be enforced by the people they protect, as I said. The issues that come up in my work and day-to-day are the disproportionality, the higher percentage of minority students in special education, stigma. There's still plenty of people who think being labeled, which is a word I don't like, as a student with a disability is somehow a negative thing, and so we fight to eliminate that stigma. The funding, full funding was never achieved. It ebbs and flows with the economy and the state of federal budgets. You'll hear the term unfunded mandates from school personnel all the time, and the law really doesn't care that you're not funded. The law says you have the right, and so I will be quoted often as saying, it's not my problem that you don't have the money for this. It's the law that says this child's entitled to it. So that's something to keep in the back of your mind. The kids with disabilities are overly segregated, even though the law requires that students be integrated to the greatest extent possible. The reality is students with disabilities are unnecessarily segregated from the general population. And I have statistics here for 2014. I think there are newer statistics that back this up as well. There are poor outcomes for students with disabilities. The graduation rates are not what they should be. So that's what we're working for. Advocacy areas, we're looking to make sure that every student with a disability receives FAPE. FAPE is a free, appropriate public education. The Supreme Court looked at what that means in 2017 in Andrew F. versus Douglas County School District. Justice Roberts wrote the unanimous decision and said that the IDEA, the Individuals with Disabilities Education Act, requires an educational program reasonably calculated to enable the child to make progress appropriate in light of the child's circumstances. And the reason it was significant was because prior to that, there was no universal declaration that a de minimis progress was enough. Some states and some school districts would say, well, as long as you get some progress. So for example, you went up a half a grade in reading. Okay, that's enough. That's not what's going to be okay under the new law. And also access. IDEA was originally an access to education law, but access alone, just having someone sit in a class, that's not what IDEA is about, and Andrew enforced that. The Andrew decision also specified, and it's not a new concept, but it enforced it again, the individuality requirement, that schools are required to look at each student individually, see what that student's needs are, and plan appropriately to meet that individual student. So often you'll hear, we don't do that. Schools will say, oh, this student needs X, Y, and Z, but we don't do that, so you get something else. There is good law to support that the school has to give X, Y, and Z if you can prove that the child can't make progress without it. So those are some concepts to keep in mind as we move forward. The other areas for advocacy are discipline of students with disabilities in the school or prison pipeline. Our kids with disabilities are disproportionately being disciplined from school for misunderstanding of their disabilities. Sometimes there is a law that says that schools cannot suspend out of school long-term students for behavior that is a manifestation of their disability. However, that is loosely applied and sometimes inappropriately so. It goes back, and I'm going to try to go through some of the laws that direct what students are supposed to be getting. But if a child is either not identified as a student with a disability early enough or at all, or if they're misidentified, sometimes that piece is missed in the discipline process, and kids with disabilities are being suspended disproportionately to their peers. The other areas of concern are English language learners with disabilities and language access. Our schools, especially in Suffolk, are not doing a great job of making sure the parents of students who don't speak English are getting information in a timely way and in their native language, even though the law requires it. And schools across Suffolk are still saying, we can't give you bilingual education and special education, you need to choose one. So we work in that area, and that's not under the law appropriate. So we work in that area to help students access both if it's necessary. I've even been told by a school special ed director that he was forbidden from referring a student for an evaluation for special education unless the student had been in the country for 3 years. Totally not legal, but without a lawyer, without an advocate, that's happening. So that's why our advocacy is so important. Moving on, students with disabilities in the juvenile justice system. Again, the school to prison pipeline. At-risk kids are being referred to PINS and being arrested in alarmingly large numbers when their real problem is a special education need that's either not being identified or not being met appropriately. I work in the PINS Diversion program alongside Suffolk County Probation Department, and I see every child referred for PINS Diversion, and I would guesstimate that 95% or more of these kids that are truant or misbehaving in school have a special education need that was either misidentified or not identified. And I can go back in their records and see issues going back to elementary school and years upon years of kids not being educated appropriately that end up with truancy and disciplinary problems. And when I try to advocate for these kids, I'm told, well, if they'd only come to school, they'd be fine. And so it's a very frustrating endeavor to try to get the schools to understand that the reason they're not coming to school, as I like to say to my kids, if I went to work every day and didn't get paid, I'd probably stop going. And that's what's happening to our kids. They're going to school every day and they're not learning, and so eventually they give up. So we need to advocate for those kids especially. Students with disabilities in the foster care system, you put trauma on top of disability and you have a really difficult case, and there's not enough resources to advocate for those kids, so those kids really need our help to make sure their needs are met. Issues of bullying, cyberbullying are becoming bigger and bigger problems in our schools, and parents don't know what to do about bullying, and schools really aren't doing a great job. There is a law, the Dignity for All Students Act in New York State, that's supposed to address it. However, A lot of schools don't understand that law and haven't been appropriately using the law, and parents are not well enough informed about how to address bullying. So that's an issue. Homeless students, the McKinney-Vento laws have been helpful in that, but we still see issues with homeless students who aren't getting appropriate educations. And then this is becoming a bigger and bigger problem, self-determination and transitioning to adulthood. Students with disabilities, as every student, is supposed to be getting an education that prepares them for after high school work or college. So that's no different for students with disabilities, and the law requires schools to start taking steps to prepare kids for after high school by the time they're 15. And most of the schools in the IEPs I've seen do not do a good job of this. And the numbers of kids coming out of high school who cannot succeed in either a job or college is astounding. And so that's an area where we're working hard to help kids get the services in school while they're still in high school so that they come out job ready and career ready and college ready. So it's a lot of work. So let's talk about how do we do that. I'm going to skip over some of the advocacy skills needed to do this so that we can get more to the law. But paramount, I don't want to skip this one because paramount in my work is to empower parents. Parents are the people who know these kids. Parents are needed to have an equal say in the school programming. The law requires parent participation. And my experience, and I will sort of qualify this by saying I see the cases that aren't going well, so my experience is skewed to the negative, but I see a lot of blaming of parents. Parents with disabilities have a lot on their plate and they're doing the best they can, and to blame a parent for not doing something that the school thinks they should do isn't really going to help the student get ahead. So we need to empower parents, understand their rights, and support parents. The idea that education is a partnership between schools and home. Parents have unique information about their child, and advocacy involves supporting the parent to ensure that they can communicate their concerns, ideas, and suggestions about their child's learning. It's not only a goal, but it's required by law. And when you put on top of that the issue of interpretation services and English language learner parents, it's a problem. So we need to make sure our parents are informed so that they can fully participate. Okay, be informed, know the law. Advocacy tips is just general common sense. I'm going to skip that right now. I will highlight, though, on this slide, if a parent needs translation, ask ahead of time, because it's fine to say the law requires it, but if you show up at a meeting and the school hasn't prepared by hiring an interpreter, the only option you're going to have is to go ahead without it or come back another day. The parents I represent, taking off another day from work is a problem, and they need to take off a lot of days from work to help their kids. So we don't want to put them in a position where they're going to have to choose between not having an interpreter or losing their jobs. And so if you can just keep in mind that an advocacy tip to call ahead, put it in writing, make sure you've made the school aware that this is a requirement so that things can go smoothly. The other advocacy tip that's paramount that I will go over, I'm not going to talk about this, but I will say that everything needs to be in writing. An attorney knows that. I think parents and advocates should know that as well. If it's not in writing, it didn't happen. You need to be creating a paper trail so that if you do have to go to a hearing, you can prove your case. So a lot of parents come to me and say, oh, I asked to be referred to the Committee on Special Education, or I complained about a bullying situation, but nothing was done. As an attorney, I don't have a lot to do. I can't fix that problem if I can't say, oh, on December 7th, you made this email and complained to this person and I had no response. That's so much more powerful and effective, so keep that in mind. Okay, so the Individuals with Disability Education Act, I'm going to take a breath because I'm talking really fast. So is everybody with me so far? We're good? Okay. So the 6 principles, basic principles to keep in mind, is that number 1, zero reject, all means all. Schools must educate all children with disabilities, and it applies to all children regardless of the nature or severity of the disability. No child with disabilities may be excluded from public education. My editorial note on this point is that of late, and the dean referred to this, students with mental illness are often told, your child won't qualify. I won't do that evaluation. Your child doesn't have a learning disability. All means all. A mental illness, there is a category in the IDEA for emotional disturbance. There's many categories which I'll go over, but I have come up of late with problems with districts refusing, and they don't like when I say refuse, but talking parents out of pursuing special education for kids with mental illness. The law requires schools to identify on their own, it's called child find, kids with disabilities, and the schools are supposed to refer to special education for full evaluations. Mental illness is often not seen as a mental illness. A lot of schools do not understand bad behavior is often a symptom of a mental illness, and they overlook that. Or, as the cases I get involved with, and even when we point it out, we get pushback. So that's important. That's an important principle. It happens, and I will say it happens rarely in what I see. However, with some education, parents are often told by schools, you don't want your kid labeled as emotionally disabled, they'll never get a job, and they'll never be able to be in the military, and they'll never be able to do any number of things. So you don't want your child labeled. So they'll hear stuff like that. And when you explain to parents the limits of what an emotional disability label, as they call it, would be, sometimes we can turn parents around. There are parents who have cultural differences that will not be interested in having their child evaluated by a psychiatrist. That does happen. And sometimes it's necessary, but sometimes it isn't. Sometimes you can get around that by using a different classification. There's one called other health impaired that might cover a disability that doesn't have to use that term ED. But often when we explain to parents that without the help, your child may be a dropout, so would you prefer dropout or labeled with a disability? That's something to be explained. A lot of it is misunderstanding. Parents don't understand they have a say at the table. They're not going to be forced into services that they don't want or they don't think their child needs. When you talk, and I'll get into this, when you talk about their rights to an independent evaluation, to have somebody you choose evaluate your student at school district expense, that will often alleviate the problem. So when we do get pushback from parents, there's often a little bit of education that can help move that off of. But it's very rare that a school is really looking to classify a student and a parent says no, at least in my experience. It's supposed to be non-discriminatory, the identification and the evaluation process, meaning that they're supposed to use a multi-faceted method of evaluations. If the child speaks a different language, the testing has to be done in their native language. I already talked about FAPE. Least restrictive environment is a tenet of the law, which says that kids should not be segregated unnecessarily. If they can learn and make progress in the general education setting with supports and services, that has to be the first thing that the school offers. Schools sometimes will use that as a defense. Oh, I can't give your child a self-contained class because it's not the least restrictive environment. But there's case law that says you don't have to put a student in a program that they will fail at just to be able to say we tried something less restrictive. So the evaluations really drive the services. So if you have an evaluation that says the child cannot learn in the general education setting and needs a more restrictive setting, then you can use that to the child's advantage. However, they can't force, schools should not be able to force students into segregated programs like a BOCES, out-of-district program, if it's not necessary. So it's really about what's appropriate. And then the procedural safeguards in the due process is really huge because that's what protects the rights of parents. Schools must follow certain procedures, and schools need to know what procedures they have to follow and hold them to it. And that there's a basic tenet that parents and students should be equal partners and participate. We encourage students to sit at their meetings as soon as their parents believe they are able, and so that they become self-advocates. Okay, so what is the CSE process and what does it pertain to? This is the Committee on Special Education, CSE, is for children from ages 5 through 21, not to be confused with the preschool special education and early intervention, which deals with birth through 5. I'm just going to talk about 5 through 21. The services are funded through the district where the child resides. A student is eligible only if all three of the following are true. And so this is an important piece. The student has to have one or more disabilities. So you identify the disability. The student has to be not making effective progress in school as a result of the disability. So you may have a very smart, high IQ student with attention deficit disorder who happens to be getting Bs because they really have a good system of managing their disability. that student isn't necessarily going to require special education services unless you can prove that there's a special education need that the student has to have in order to make progress at school. And that's the third one. Students require special education in order to make effective progress. So parents need to come prepared to understand, what's my student's disability, how is it impacting them in school, and what services do they need to address it. That's the three pieces. The process, you start with a referral. Again, it has to be in writing. I advise parents not to rely on the schools to make the referral. Parents are able to make written referrals directly to the Committee on Special Education. The referrals trigger evaluation. Parents must sign written consent for the student to be evaluated. Evaluations are required by law to be in all areas of suspected disability. And the reason I raise that is because schools like to do psycho-ed testing only. Psychological and IQ test, education, a academic achievement test, and then make a decision based on that. However, if your child has ADHD or bipolar disorder or depression or anxiety or any number of other disabilities, a psycho-ed test isn't going to identify it, and the school then will have a CSE meeting and say your child doesn't qualify. So advocacy is needed to make sure the school tests the student in all areas of suspected disability. After the evaluation, you have a CSE meeting, an IEP, which is the Individualized Education Program, is developed. Then the Board of Ed arranges services, and all of this must happen within 60 days of signing consent for the testing. Important point, because parents will say, I made the referral on April 1st, and they didn't do it within 60 days. But if they didn't sign consent until May 1st, they have from May 1st 60 days. You have to sign that consent as soon as you make the referral. And then everything gets revisited every year to make sure it's still appropriate. This just talks about the 60-day timeline. This is more advocacy. I don't know why that's blank, sorry. Oh, okay. These are the names of the people that need to be at the meeting. Basically, a CSE meeting should include anybody with relevant information, and there are required people. I'm not going to go through that. The parent's rights, this is important. The parent can give or withhold consent for an initial evaluation. They have the right to receive prior written notice of all meetings and decisions. So one of the areas that we do a lot of advocacy around is parents say, the school called me and said they're doing a CSE meeting in 10 minutes and I have to come, and if I don't come, they're doing it without me. Well, that's not legal. So the parent should be empowered to know that they can say, I'm not available in 10 minutes. You are required to give me written notice with ample time to be able to be there, and I want you to reschedule it at a time that's mutually convenient for both of us. That's the term that's in the law, mutually convenient, and schools need to respect that. As an attorney or an advocate, if a school holds a meeting without the parent and they didn't do the proper notice, it can be redone. So that's a good result. The parent has the right to request changes in meeting dates, times, and locations, what I just said. Have an interpreter, participate in decision-making. One of the biggest and most important rights is the right to request an independent evaluation if you disagree with the district's evaluator. Sometimes school districts use an evaluator, and the parent says, I don't recognize my student in that evaluation at all. The student's parents then have the right to put in writing a request for an independent evaluation, which means they can ask the school to pay for a second opinion, and the parent picks the person who will do the evaluation. It's really not a problem getting those evaluations as long as the person you choose has the same credentials and charges about the same as the school district's evaluator. So, and then you come to CSE with both. One doesn't have more weight than the other, but the evaluations all get looked at and have equal weight to make decisions. Okay, parents have the right to have confidentiality maintained. They have the right to receive copies of all their reports. They have the right to examine all their school records. They have the right to appeal CSE recommendations. Parents are always a member of the CSE. The school cannot hold the meeting without them unless they have made a strong effort to include them. So parents, sometimes schools will say, I invited the parent, they didn't show up. I invited them again, they didn't show up. The law will let the school continue with the CSE meeting absent the parent if they can document strong methods and attempts to get the parent there. Parents can invite anyone they want. It's a very emotional process. Parents can invite their best friend. They can invite an advocate. They can invite whoever they feel is relevant to the conversation and whoever they feel would support them through the process. So that's a nice right for parents. Sometimes they need to give the parent notice, as in if they're bringing an attorney, they need to give the district notice that they're bringing an attorney. There's a parent member sometimes that is included. Parents want someone who is not related to the family, but who has been through the process with their own child. That's called a parent member. It's not a parent advocate. The person isn't there to advocate for your position, but you can ask for that person to be included. The law used to say they had to be there. Schools had a hard time getting parent members to participate, so the law was revised to say that if a parent wants a parent member, then they have to ask for it. So I don't usually see parent members at meetings anymore. And the parents have the equal right to question anyone at the table who has an opinion. Okay, the purpose of the CSE meeting is determine eligibility, classification, what the needs of the students are, the present levels of performance, including the strengths and needs, services needed to meet the needs, the goals, where the student will receive the services, and develops the IEP. Everything is determined by an evaluation. So an important advocacy point is to make sure the CSE doesn't start with, okay, everybody agree we're going to put this child in a 15-1 class. If that's how the meeting starts, we're in trouble, because it's supposed to start with, what do the evaluations say about this child? How does it identify the needs and weaknesses of the child? What are the needs of the child? How will this child need support to be able to make appropriate progress? And then you come up with, what are the goals to get this child what they need? And then you come up with, what does that look like? Where will they receive the service? So it's really important to identify what the present levels of educational performance are, because that's the measure you're going to have to decide whether a free, appropriate public education was received, because you want to see a year's progress in a year's time. And if you don't identify what the student's level is at day one, a year from now, you won't know if they made progress. So important piece. The other important piece for parents to know is you don't have to wait a year for your annual review CSE meeting to question whether or not the services are appropriate. Parents always have the right to request a new CSE meeting to go over the program. They have the right to request additional evaluations. They have the right to request additional services. Doesn't mean they'll get it, but they have the right to have a new meeting. And so sometimes parents will come to me and say, well, I waited a year, nothing happened this year, he lost a year. And I'd be like, I wish you had come to me sooner. You could have asked for meetings sooner so we could address it as needed. A lot of times schools will review the reports prior to the CSE meeting, and that's a good thing. It's called a team meeting, and they'll go over the data they've collected and give the parents a heads up. Sometimes they don't do it on their own, but if you request it, they'll do it for you. And again, if you don't agree with the evaluation, you can ask for an independent evaluation. Okay, so this is the slide that identifies the 13 identified categories of disability. This is in the law. You have to meet the criteria for each one. They're defined in the law, and the ones we see the most are learning disability and other health impaired. Speech and language impairment tends to fade away as kids get older. You see that a lot in elementary school, but not so much in high school students. Emotional disturbance is a lot of my focus these days because it's misunderstood. You really need to read the law and to apply it to the facts. And again, other health impaired might cover it, so you don't really always need to use ED. Autism has become a little more complicated of late with the change of the DSM-5, but I still see kids classified with autism. And then multiple disabilities, so sometimes kids have more than one. Intellectual disabilities is for students with low IQs and cognitive delays. The services that are provided to the student are determined at the CSE meeting. They delineate, it's your contract with the school, so the IEP is going to say when the services are provided, how often the services are provided, where they're provided, and what large groups. So a child might be getting speech and language services. It could be individual, it could be groups of 3, it could be groups of 5. All of that data needs to be on the IEP because that is your document that you can enforce. If it's not in there, it's harder to enforce it. The regulations only provide minimums, so if you see in the regulations a certain amount, the school can always give more if it's appropriate. Goals are supposed to be developed at the CSE with input from the parents to identify what the teachers are working on, what the providers are working on to make the progress that's required. Progress reports must be provided as often as report cards. So a student with a disability and an IEP will get a regular report card, but they'll also get a progress report. That progress report will be achievement towards meeting the goals. So you want to keep an eye on that as a parent to see if they are making adequate progress, because again, you might want to call a new CSE meeting to address the lack of progress. Or if a goal has been met and it's only, February, maybe you want to have a new CSE to create a new goal to have them work on the next step, because you don't want to waste time. Okay. Skip that. Where the students receive the service, least restrictive environment. I talked a little bit about that. Placement of students with disabilities in special classes, separate schools, or other removal from the regular education environment should occur only when the nature or severity of the disability is such that even with the use of supplemental aids and services, education cannot be satisfactorily achieved. So again, the concept is you want all kids to be educated together regardless of disability, unless they can't make adequate progress in that setting, and then you bump it up. There is a continuum of services, so being in a regular class with a resource room might be the least amount of services that pulls you out of a regular ed class, and then being put in a different building that only teaches kids with disabilities, that's more restrictive. So you want to work it so that it's the least restrictive, but it is appropriate to meet your students' needs. Okay, this is the continuum of services from regular class all the way up to residential. So you want to think about each step and whether or not that's appropriate to meet your child's needs. Okay. I think I covered that. Okay, advocacy tips. That's pretty self-evident. I want to leave some time for questions. You want to remember to keep the meeting child focused. It's not helpful to talk about the teacher's child or what happened with another child. It's important to keep it on the child and what the child's needs are and what the child's strengths and weaknesses are. Okay, negotiations. Okay, after the meeting. Okay, so what I wanted to get to was when parents don't agree. It doesn't always work well, and parents will leave a CSE meeting and say, I didn't get what the child needs, they didn't hear me, they didn't listen. So it's important to understand that you don't have to go directly from a CSE meeting to a due process hearing. There is, in the law, there are steps. It's an administrative process. You're required to exhaust your administrative remedies before you can go to court, and it's pretty defined by the law. Sometimes advocacy solves the problem. My agency is staffed by advocates who are not lawyers. In addition to lawyers, the advocates working with the lawyers can create an advocacy plan that is often successful without having to file a hearing. Hearings can be complicated and take time, and so you want to resolve the problems as fast as possible. So one of the first things we look at is, can we get an independent evaluation to give us the evidence we need to convince the committee to give this child services that the parent feels the child needs? So that's one way. Sometimes it's helpful, you go above the person who chaired the CSE meeting may not be the district chairperson, and you can ask for a meeting with the district chairperson. So everybody has a boss. Sometimes it's important to go up that chain of command. You want to look at the school district's policies. Okay, if it was a subcommittee meeting, you can request a full committee meeting. If it's a full committee meeting, you can ask for another meeting and bring maybe an advocate this time if you hadn't the last time. And then you can go to due process. Due process is the system where you file a formal complaint against the school district and you ask for a fair hearing. The fair hearing does have testimony, just like any hearing, and it's decided by a designee of the school district. I must say that in my work, we don't often get to to due process hearings because we are successful often in resolving the problem prior to getting to a superintendent's hearing. I will preface that by saying that we don't do a lot of work with parents who are seeking tuition reimbursement for private placements. That's an area of law where private attorneys are often available to parents because there are attorneys' fees that are part of that process. So my agency is primarily representing low-income people, and that is not something we are pursuing. We're referring that out. So other attorneys might have different opinions. If you do want to proceed with a hearing to request a private placement at school district expense, there's certain criteria that you would have to prove. One, you would have to prove that the school district failed to provide you with a free appropriate public education. Once you overcame that barrier, if you were able to prove that, you'd have to prove that the school that you chose to put your student in can meet your student's needs. And then the third prong of the test is, are the equities on your side, which can be pretty vague and subjective. So a case may be lost for a parent if the school can prove that the school tried to, for example, set up a screening at a BOCES placement and the parent refused to look at it because they didn't want their child in that program, and so they wouldn't even look at it. That could end the case right there because the equities wouldn't then be on the parent's side. So that's just a real quick way to look at it. You can ask for a meeting with the superintendent. You can file a state ed complaint. So if you don't have the funds for an attorney and you don't want to proceed to a fair hearing, you can call the state education department. There's a regional associate's office that will look into complaints. It's a pretty simple process. You can get the complaint form on the New York State Education website, and that is sometimes a faster and easier way for a parent to lodge a complaint. I often use state ed complaints when schools are failing to follow due process requirements. For example, one of the schools in Suffolk has been routinely telling parents they will not evaluate their students because the student's truant, or they don't think the child would be qualified as a student with a special education need. So we have been advising those parents to call state ed or do state ed complaints to compel the district to follow the law. So that's a pretty black and white issue. It's not subjective as to what the school, the student needs and what the school needs to provide. And then, of course, the impartial hearing. And then these are just some current issues that are pending. I think I'm going to stop here so we could ask questions since we only have a few more minutes. You're welcome. Sorry?
I really appreciate, Eilleen, your presentation, and I just want to thank you on behalf of the law school. This presentation is part of an ongoing series and ongoing project in the law school dedicated to disability rights, generally to special education in particular. Many of you attended or watched the presentation a couple of months ago on the IEP process, and today's presentation was just so perfect in terms of the goals that we are pursuing and the ideals that we're trying to realize in terms of our responsibility to individuals, to students with disabilities, to providing the appropriate education. And we as lawyers in particular are so happy to have, we at Touro are so happy to have LIAC, to have the Long Island Advocacy Center here as part of our PAC. And once again, thanks Eilleen, thank you all who helped organize today's event. Thanks those of you who are now watching on the live stream and those who are watching the recording. And we do hope we will continue to have future events. So if you have any suggestions, any input you'd like to provide, by all means, please send them our way. And Eilleen, we'll spend a few more moments. We appreciate you taking your time to respond to questions.
Anybody have any questions? Okay. Yes, we do. That's a good question. I think that it depends on the impact of the diabetes on the student. A student with diabetes might only need a 504 plan, and I didn't really get into the difference between an IEP and a 504 plan, but a 504 plan is, as I said, an anti-discrimination law. So if a child needs accommodations but not special education, the 504 plan might meet that criteria, and certainly diabetes would fall into that. There's also a medical health plan that can be filed with the nurse, so there's different requirements. If the child with diabetes has a learning need that requires special education, then they might qualify under IDEA. Like I said, it depends on the individual child and what the evaluators and the medical evidence shows. Yes? We take interns, we participate in the job fair, we're happy to have law students work with us. Actually, summers, semesters, it's probably better actually during the school year when school's open, but we do take summer interns. So yeah, just have them contact me. Yes. Yeah, I think all of the above, unfortunately. Lack of understanding on the parents' part, lack of understanding on the teacher's part, lack of enforcement of the law of child find. Child find, whereas it's a good law, I rarely see schools initiate special education services. Part of that is just a personal opinion, but I think it's lack of funding. Schools are also under state mandate to keep the numbers of students identified as having special education needs under a certain cap, because there was concern back in the day of over-identifying kids and segregating kids into special education, so they walk a fine line. So I'm not saying it's deliberate. I do think there is a complicated formula. My personal opinion and my advocacy work is involved in saying you cannot make that decision without getting the evaluations and then identifying each kid specifically based on the information you've acquired. So I work really hard to make sure schools get to at least that phase. You know, you have to have all three components. You have to have a disability, it has to impact your education, and you have to need special education. So sometimes a kid with a high IQ who has a mood disorder may not need special education per se, because they can learn fine, but they need supportive services to address the mood disorder, and that may be qualified under 504, as I said, but a lot of times it goes under the radar. A lot of our kids are developing mental health issues in late teenage years, so there's that as well. But it's a combination of issues and funding. These programs have never been fully funded, so that's a problem. I hope that answered your question. That's a tough one we struggle with. All right, I think we've reached the time limit. So thank you for all coming, everybody for coming. And if you're interested in getting an email of the PowerPoint, just let, I guess, Sid. You would know, Sid?